supposed to be coming down this thing. I only made it on the train at 5 to 2 from Cambridge.
Miss Roberts, we were on the supplementary bundle. Oh, forgive me, Miss Richards.
That's quite all right.
Supplementary bundle.
We're on the supplementary bundle. Just before I turn back to some of the documents, no change of answer to my Lord's question.
Thank you.
I'd jumped in with documentation from January 2021, but there were in fact 2 documents from 2020 that the judge relied on, which I should have taken the court to. It won't take long. Supplemental bundle, page 343. This is an announcement in April 2020 about the national strategy for disabled people to remove barriers and increase participation. And if you look towards the last 4 paragraphs on page 343, we see reference there again to the development of the national strategy. And then it says the strategy will build on evidence and data and, critically, on insights from the lived experience of disabled people. And that's one of the passages highlighted by the judge. And then over the page, having set out what was said to be some broad objectives for the national strategy, the last paragraph on page 344, picking it up from the second line, we want to ensure we have enough time to get this right, etc. People's views and insights will be crucial as we work with colleagues across government, etc., on possible solutions. Again, that suggestion that views and insights will be crucial was relied upon by the judge. And then the second document from 2020 is 2nd of December 2020, the next page of the supplemental bundle, page 345. Again, reference to the national strategy. And you'll see above the photo, it says a key focus will be on practical action that will make a tangible difference to disabled people's day-to-day lives. And then over the page, there's reference to the early discussions with disability stakeholders, identifying themes. And then just above the heading, what is the government doing? You'll see 2 sentences. It's not a complete list. We're continuing to listen to stakeholders to find the right areas to build a strategy that makes a real difference to the lives of disabled people. Again, a passage referred to by the judge. And then, if I might just go back to one of the documents I showed you before lunch, because there was a page I omitted to take you to, page 151. It's a document that starts on page 149, which was the overview announcement of the survey. And I showed you, I think, page 149 and pages 152 and 153. But I think I omitted to just show you in relation to page 151. Again, you see the reference to sharing views in the question. And then in the 2 paragraphs down, you'll see just 2/3 of the way down the page. If you're unable to complete this survey, but would like to contribute your views on the national strategy. So what was said to be being elicited is not simply the lived experience of disabled people, but their views, and views is used quite generally in the documents we looked at before lunch, but here it's specifically views on the national strategy. And then I won't go back to any of the other documents that we looked at from January 2021, If you then turn, please, to page 353, you will see there, and again this was referred to by the judge in paragraph 64 of his judgment, the survey was cited on the consultation hub and described by government as an open consultation. And then in
Just
terms
hang on
of
a second, please.
I'm sorry,
I've just got a malfunctioning file. 353.
353.
Yeah.
And then if we turn to the survey itself...
What did you want us to look at 353?
It's the fact that the survey was cited by the Disability Unit on the government's consultation, or on something called Consultation Hub.
Yes.
And described at the relevant time as an open consultation. And then, if we turn to the survey itself, starting on page 154, not going to go through the detail of the questions, but you will see that they are all questions which permit only, or for the most part, multiple choice answers. So if, by way of example, if you look at page 163, question 19, how much effort is needed to get in and out of where you live on the part of you and any carers? There's an option to say, an answer to one of 5 options, from no effort to an extreme amount of effort. But as you will have seen, or will see from the evidence of the respondents, their particular concern was that none of the questions provided the opportunity to explain how something impacted upon them, rather than the fact of the impact, or what might be capable of being done in response to it. And then in terms of the non-multiple choice questions, there were only 4. The first is at page 209. Sorry, one picks it up at the bottom of page 208. It's question 109. And it's about comparing differences before and after the pandemic with a 250-word maximum. And then, if you turn to page 219, you will see questions 111 through to 113, which enable the respondent to give a 100-word maximum answer to each. There's a general question about changes that would make your life better or improve your life, top 3 changes to be answered in 100 words maximum. Then question 112, if you feel we've missed any issues or barriers, please set them out. And question 113, building on your experience or insights, can you suggest any solutions to issues raised, or how to remove barriers? But what there hadn't been in any earlier part of the survey, or any material supplied with the survey, is the actual identification of issues that might then form part of the subject matter of the strategy. So a question that's both so general as to be almost impossible to meaningfully answer, but also a 100-word maximum in terms of any response. The last piece of information which the judge expressly relied upon in this part of his judgment was the strategy itself. He deals with that in paragraph 65 of his judgment. If you turn briefly to the strategy, which starts on page 226, I can just highlight a handful of the passages in question. So page 232, you will see top of the page that the strategy is described as having been formulated with the input of more than 14,000 disabled people. And then if you go to the top of page 234, you'll see the statement from the appellant. We carried out the biggest listening exercise with disabled people in recent history. As a result, this strategy is far more wide-ranging than approaches of the past. Informed by what we've heard, the strategy sets out the actions that will positively impact part and every part of disabled persons' everyday lives, and then a number of examples given. And then, if you turn over to page 235, under the heading about this strategy, you'll see it said a huge range of organisations and individuals have shaped the development of the strategy. And then bottom of page 235 there, we're grateful to everyone who's taken the time to share their thoughts on what we should include in this strategy, whether through completing the UK Disability Survey and then a number of other means set out. Their expertise and insights have been integral to the development of the strategy. And that's as clear an indication as any of the others of the link between the purpose of what I'll call, for the sake of argument, the engagement, the invitation, and the subject of the strategy. We've seen references to asking for views on the National Disability Strategy. Here it said, share your thoughts on what we should include in this strategy. That isn't what the survey actually achieved, but this is an indication of what it was intended to achieve, and goes in our respectful submission to the characterisation of that as a consultation. And so you would have seen from the judgment that the judge's view that the way in which the strategy claimed to be responsive to the survey further demonstrated that it was intended in substance to be a consultation, to be a conversation, a dialogue, rather than just a broad information gathering exercise. And so we then come to the conclusion in the judgment back in the core bundle, page 49, paragraph 66. The material I've gone through is the material highlighted by the judge in the immediately preceding paragraph. And then the conclusion, paragraph 66. The defendant voluntarily embarked on a consultation to which the Gunning-Moser principles should be applied. I'll come back to that second element in due course. And the survey was at the heart of that consultation. Now, leave aside the question of the use of the language consultation. The defendant, appellant, voluntarily embarked on, in our respectful submission, a process at which the survey was the heart to obtain views, ideas, information, and perspectives that were designed to be directly relevant to the strategy itself. And then, as he goes on to say in paragraph 66, although I've described the strategy as preliminary in general, it was not lacking any substance. It's not so high level that it's the absolute abstract area of public policy. It made immediate commitments, set out ambitious changes, summarised actions each government department will take. It was capable of attracting, if the defendant chose to assume it, a consultation obligation. That was a conclusion, in my respectful submission, which the judge was perfectly entitled to come to on the material before him. I think it's fair to say there is no definition of consultation given in the judgment. There's no definition, I think, of consultation given in any of the authorities that we've identified. From time to time, there is a case which touches on what isn't a consultation. So we see that in the APIL case, the judgment of Lord Justice Elias that Sir James referred to. The fact that there are meetings, or to give some of perhaps the more extreme examples Sir James gave, the minister goes on television and is interviewed, or sets out his views and is in conversation with somebody else, or has discussions with a member of parliament whose constituent is raising issues. I'm not suggesting that those are consultations. I'm not suggesting that any form of meeting, any form of engagement, any form of evidence gathering necessarily becomes a consultation. And that's really is the judgment of Lord Justice Elias in the April case really takes the matter no further. It tells you that certain things weren't a consultation. It doesn't actually tell you what is. Likewise, the Greenpeace case, decision of Mr. Justice Sullivan, as he then was, doesn't say an issues paper can't be the subject of consultation, the point in that case was that the consultation on what correctly analysed was an issues paper was not sufficient to discharge the legitimate expectation, the precise promise that had been given in that case as to what would be consulted on. So the judgment of Mr. Justice Sullivan in the Greenpeace case doesn't really take the matter any further forward, one way or another. I think both parties have cited it in their skeletons, but in fact, it doesn't really assist any further. And so there being no legal definition, no term of art, precise term of art as to what is a consultation, it was perfectly open to the judge to analyse the material before him and to focus on the contemporaneous material, as I say, not the ex post facto description given by Mr. Bell. And I don't mean that pejoratively, but just as a matter of fact, it's what the documentation shows at the time that was key, rather than a civil servant later saying, well, we might have put it on the consultation hub, but we didn't mean it to be a consultation. He analysed all that material and reached a view that was, in my respectful submission, plainly open to him on the facts to reach the decision set out in paragraph 66 of his judgment. As I hope our submissions have already made clear, we're not suggesting that a decision maker can't undertake a broad information gathering exercise. But this was something else. This was an invitation to disabled people for the express purpose of shaping a policy that was already partway in process of being formed and then emerged at the outcome of the process.
Given that the survey asked a series of very detailed questions, what room is there for an inference that the government was doing something else other than asking the questions in the survey?
Twofold, my lady. First, the information, the documents which I've already shown you, which talk about eliciting people's views, not just lived experiences, which it might be said to some extent, the questions in the survey provide information about lived experiences, although with all the limitations described in the respondents' witness statements. But the government itself had indicated that what it wanted was to elicit views. You'll see there's a document I haven't yet taken you to that refers to eliciting people's insight. You've seen the reference in the survey itself to asking about issues, barriers, and solutions. It was intended to, in terms of what it was said the purpose of it was, to go further than that which the bulk of the questions in the actual survey ultimately permitted.
So the survey is to be construed by reference not just to the questions that were asked, but by reference to something else that can be deduced from the language in the survey. Is that the submission?
No, my lady.
No? All right. What is it then?
The submission is twofold. Firstly, that the survey does not fall to be viewed in isolation from the other documents which I have taken the court to and which the judge relied on,
Right.
which state in terms what is being sought in terms not just of answers to questions about your current experiences, but your views on the strategy is the terminology used in a couple of the documents as we've seen. So we look to see what the appellant was actually saying it was proposing to do and the purpose of what it was proposing to do.
Yeah.
And then secondly, when we look at the survey itself, the questions at the end, the ones which permit 100-word maximum answers,
Yeah.
do go more widely, with the limitation of the word limit, in terms of the kind of matters that one might expect to have been canvassed in a consultation. They ask for for thoughts or views in relation to issues that haven't been raised, to barriers, and to for solutions. But the difficulty there is that the respondents to the survey won't have been provided with any kind of information that would enable them to meaningfully respond.
I see. That's very helpful. Thank you.
My lady, Lady Justice Laing had asked about whether there were other cases in which there had been high-level consultations, if I can put it that way, consultations in which they weren't focused on specific proposals. And I think questions have also canvassed whether there are any authorities which tell us what a consultation is, as I hope I've already answered. There doesn't appear to be in relation to the latter.
Yeah.
And the voluntary consultation cases, the public body doesn't habitually dispute that there's been a voluntary consultation, which is why there may be a dearth of case law precisely on that. Mr. Broach did identify over lunch what appears to be a voluntary high-level consultation case. I haven't had a chance to read the judgment, my lady, so, and obviously nor will my learned friends. I'm just going to give you the reference.
Okay.
Obviously, if it's to be placed before the court properly, we will do it in the proper manner, and,
Sure.
and with my learned friend being able to respond.
That's very helpful.
But it's a case called on the application of Doncaster Metropolitan Borough Council and Doncaster Sheffield Airport Limited and others, 2022 EHWC 3060, judgment of Mr. Justice Fordham.
Can you give me that reference again?
Yes, 2022 EWHC 3060, admin.
Yeah.
It's a judgment of Mr. Justice Fordham. I'm told the relevant paragraph is paragraph 21. It was a voluntary consultation case, and in terms of the scope of the consultation, it was in fairly general terms, the future of the site and how best to maximise and capitalise on future economic growth opportunities for Doncaster and the wider Sheffield City region. In fact, it was a case that was unsuccessful because on the facts, as I understand it, it was found that the gunning criteria had been complied with. And it doesn't appear to have been positively argued along the lines that Sir James is arguing today, that it didn't attract the gunning criteria. But I didn't want to leave any stone unturned.
No,
over that.
thank you very much.
There are other cases, again, at a relatively high level of generality. So there are authorities in which there has been what was accepted before the court is a voluntary consultation about adult social care cuts, where there isn't a specific proposal about what should be cut. But there is a consultation process voluntarily undertaken to gain people's input and views, which, as far as I can recall, has always been accepted, would attract the gunning requirements. An example of that, again, I haven't had a chance to check over lunch whether it lives up to that billing, is a case called T in Trafford, 2015 EWHC 369 admin. If those are cases which we think would be useful to the court, I'll check them properly at the end of today.
I'm so sorry, could you just give me the reference again?
Yes, 2015 EWHC 369 admin.
Thank you very much.
As I say, if they are cases which we think would genuinely assist the court, we'll provide copies, and
That's
obviously
really
Sir James would need to be able to make submissions on them, and indeed I would need to be able to properly read them and make submissions on them. Insofar as Sir James's submission that you can't have a consultation if you don't have a proposal, I hope I've already addressed that sufficiently. There isn't, in my respect to submission, an authority which establishes that. It is absolutely right that the authorities often talk in terms of proposals, because most or many consultations take place where there are specific options that are being advanced. We say proposal, in any event, falls to be widely rather than narrowly construed. And we've set that out in the skeleton argument, paragraphs 39 and onwards. I won't go through everything that was there set out. One of the submissions that Sir James has made in terms of advocating a narrow approach to what should be characterised as a consultation is by reference to the consequences that would flow, leaving aside his second argument, in other words, the gunning requirements. And you will recall the terminology used by Sir James in the course of his submissions about onerous procedural requirements, onerous procedural baggage, words to that effect. I'll come back to this when I deal with ground 2. In my short submission, there's nothing particularly onerous, in fact, about the gunning requirements. And so the fears that were trailed by Sir James as to how this would constrain or inhibit government decision-making are in my submission without any real foundation. These are fairly basic minimum requirements of fairness, but I will, as I say, I'll come back to that a little later. One of the other points made by the appellant, both in the skeleton argument and in Sir James's oral submissions, was to say, well, look, you can tell it's not a consultation because it didn't have proposals in there, it didn't have information in there. That's the wrong way round, in my respectful submission. And as the judge observed in his judgment, to say it wasn't a consultation because there wasn't specific enough material in there would be to allow the appellant to rely upon their own breach of the gunning principle as a basis for saying that the survey was not a consultation. We say that can't be correct. But shortly, and we say this is the right way round to look at it, the strategy was a policy intended to make important practical and policy changes, that's what the government itself says in various documents, in which the views of disabled people were said to be necessary, to be central, to need to be elicited. That is a consultation. Or put another way, on any view, the judge was not plainly wrong to conclude that it was a consultation. Insofar as some of the other matters raised in the appellant's skeleton arguments concerned, in particular, I think it's paragraph maybe paragraph 20 of the appellant's skeleton argument, but in any event, we've set out, and this is an area I don't propose to repeat, but just take from my skeleton argument, we've set out in paragraphs 48 to 51 our response, of our skeleton argument, our response to certain submissions the appellant's skeleton makes about the judge failing to take into account particular factors. We say, for the reasons set out there, there's no basis for concluding that the judge failed to have regard to those matters. And a proper reading of his full judgment would indicate that he did, and that the real complaint is in relation to the importance or weight which he attached to it. Can I then just take you, finally, before I deal with some of the case law that Sir James referred to in relation to issue 1, to a couple of further documents. These are not documents, I think, that were expressly relied on by the judge in paragraphs 61 to 66 of his judgment, but they are nonetheless, in my submission, instructive. So if we start with page 69 of the supplementary bundle, forgive me, my inability to read my own handwriting. Yes, so these are just two internal documents, possibly three internal documents, which talk about what the contemporaneous understanding was of the importance of the input of disabled people into the development of the strategy. Paragraph page 69 is a ministerial submission from September 2020, is anticipating the survey stage, and at paragraph 5.1, so the penultimate paragraph, it refers to the ministerial statement that you want stakeholders and disabled people's lived experience to be at the heart of the development of the strategy and green paper. And then, if you move to page 76, you'll see a further ministerial submission a few days later. And if we just turn to page 77, paragraph 4.7, said to be the key messages. The second bullet point talks about the ambition for the national strategy, that it will set out practical steps to remove barriers. And then the fourth bullet point, critically, the strategy will involve insights from the lived experience of disabled people. We wish to ensure that we listen to and are led by the voices of disabled people. And in our submission, that begs the question of how you can be led by the voices of disabled people if you do not give them the adequate opportunity to respond. And then the third document is page 117. And so this is a further ministerial briefing. This is from October 2020, so a little later than the first two. And just picking it up under the first three questions, which are purpose, how and why, it says this: we're looking to put the lived experience of disabled people at the heart of what we do. The way to do this is to capture disabled individuals, 1, experiences, 2, insights into what constitutes barriers, and 3, solutions they might be able to offer. That is a clear indication in my submission that what was the process that was embarked upon was intended to be more than just information gathering about the answers to the multiple choice questions, the lives of disabled people, but was to seek to glean insights about barriers and proposed solutions. And then finally, well, we see essentially a repetition of the same points on page 119. I don't think there's any particularly discrete point I need to refer to there. Save I invite you to note under core objectives in the second bullet point the reference there to government consultation exercises. And so, standing back, looking at what the appellant articulated was the purpose of what the government was doing, to formulate this strategy, this policy, this plan, doesn't matter what one calls it, that would identify practical actions to substantially improve the lives of disabled people, building in their views, experiences, their insights and their solutions. That is, on any view, a consultation exercise. And so, leaving aside ground 2, the only question then is, did the exercise meet the Gunning criteria? And it was not disputed before the judge that it did not. It was accepted that the exercise did not provide the sufficient information.
I think Sir James has conceded that again this morning.
And what you will see in paragraphs 73 to 78 of the judge's judgment is the judge's own articulation of the deficiencies in the process. I don't propose to go through those, but they accurately summarise what was wrong with the consultation. And then I won't take you to them, but I gave you the references this morning to the statements of the respondents, included within that the statement of the lateness finder, and I do ask the court, as I say, to look through those, because that will throw into sharp reality both the importance of the exercise, but also the deficiencies in what was in fact done. Can I then, before I turn to ground two, just deal with a handful of the submissions made by Sir James by reference to some of the case law, some of the principles. Sir James's broad submission on the question of how to characterise whether something is a consultation was in two stages. And in terms of his principled approach, which was his first stage, he said there was a dividing line between consultation and public engagement. And then submitted that the extent of the significance of distinction flows from the legal incidents that flow and whether more onerous obligations flow. Take that second point first. In other words, in deciding whether something is a consultation or not, you consider the fact that, if it is, the gunning requirements follow. That, in my submission, is not logical or principled and looks at matters the wrong way round. First, you must identify whether it is a consultation. If it is, then certain minimum requirements of fairness follow. But to say, well, it would be unattractive or problematic or difficult for government or contrary to the separation of powers to have these consequences cannot feed into the question of whether something is or is not a consultation. In relation to the suggestion that there's a dividing line between consultation and public engagement, as I hope is clear from the submissions already made, we certainly accept that there is not every form of engagement or information seeking will amount to consultation. But none of the authorities in my submission provide any particular guide or suggest that there is some kind of clear dividing line between the two. Sir James then suggested, in reliance in part upon the observations of Lord Justice Elias in the Apil case, that whether something is to be characterised as a consultation should in principle be rare. There's no good reason why that should be the case. Again, it's looking at it the wrong way round. That's a consequentialist approach. That's where I think Sir James used the terminology of onerous procedural baggage as a description of the gunning requirements, which they plainly are not, and raised or reverted to his submissions about the important constitutional principles of separation of power. Short answer to that is requiring a public body that's decided to embark upon a particular process to do so in accordance with basic minimum requirements of fairness does not interfere with or offend any principles relating to the separation of powers. I think there was also a suggestion that to take anything other than a narrow approach to the characterisation of something as a consultation would disincentivise engagement. And that is an unattractive submission, in my respectful submission, for the government to advance, to say, well, we'll be disincentivised from engaging where otherwise we think it's a good idea to do, because we don't want to have to be forced to do so in a way which the law recognises as fair. The remainder of my learned friend's submissions, specifically in relation to the requirements for there to be a proposal and so on, I have, I anticipate, already set out our response to. And I don't think there's anything there that I need to repeat. Other than in relation to Sir James's submissions on the facts and on the judge's reasoning, there was a particular submission made by Sir James by reference to paragraph 61 through to 66 of the judgment, that the judgment was premised on the fact that the Secretary of State used information from the survey to design the strategy. And he says, well, that can't possibly be sufficient to make it a consultation. That clearly wasn't the approach taken by the judge on the facts. It was the link between the invitation to participate and there being an ongoing decision-making process that he regarded as significant. He didn't say simply because reference was made to the outcome of the process that must, without more, render it a consultation. And then Sir James suggested that it was telling that the strategy identified a number of proposals for future consultation in specific areas. That, in my submissions, nothing to the point. It neither proves nor disproves in anybody's case. There can clearly be staged decision-making processes and consultation on different matters at different stages of the process. It doesn't help understand whether what was being done at the relevant time for the purposes of this case was or was not a consultation. Can I then turn to the second ground? And there is obviously a preliminary issue as to whether the Secretary of State should be permitted to rely upon that ground. The court will appreciate this is a point that has at no point been taken pre-action pleadings before Mr. Justice Griffiths in the application for permission to appeal to this court. At no point taken until a relatively late stage. If you turn to the authorities, or the authority which Sir James took you to, tab 29, please. So this is the Brent and Johnson case, and the passages started on page 870. Sir James emphasised what was set out from Singh and Das at paragraph 38. But if you would kindly turn over to page 871, paragraph 41 of the judgment, which sets out quotations from this court's decision in Prudential Assurance Limited and HMRC. It starts at paragraph 40 on page 871. And then paragraph 41 explains, sets out the starting point in the final sentence of what is paragraph 23 of the extract from Prudential Assurance. And then paragraph 24, parties to litigation are entitled to know where they stand, tailor their expenditure and efforts in dealing with what's known to be in dispute, disproportionate allocation of court resources for the Court of Appeal. The Court of Appeal deals with the point for the first time. It's neither a review nor a rehearing. And then, top of the next page, general public interest in the finality of litigation. And then this, if the point is a pure point of law, and especially where the point of law goes to the jurisdiction of the court, an appeal court may permit it to be taken for the first time on appeal. And then it said if successful, it would require further findings of fact. That would be very rare. But then this, in addition, before an appeal court permits a new point to be taken, it will require a cogent explanation of the omission to take the point below. And there has been no explanation whatsoever by the Secretary of State of the failure to take this point in the court below, a point that was just as open to be taken then as it is now. That, in my respectful submission, should be the end of the matter in terms of the application for permission to rely upon this new point. It is difficult to imagine a claimant in judicial review proceedings being permitted by the Court of Appeal to raise a new ground of challenge for the first time in this court without explanation, and the Secretary of State should not be held to any different standard. In terms of the prejudice that may have been suffered by the respondents, it is as follows. The thrust of my learned friend's argument in relation to this second ground is, well, it may be a consultation, but it's a voluntary consultation, and therefore gunning principles do not apply. Therefore, the only basis for challenge is a Tameside failure to discharge the obligation of sufficient inquiry. that was not the way in which the case was put at any stage prior to recent months. And that has effectively deprived the respondents of the action that they might have wished to take. If this argument had been set out at the pre-action stage or at any stage prior to the hearing before Mr. Justice Griffiths, the respondents may have wished to plead an alternative fallback tame-side argument. But when the matter got before Mr. Justice Griffiths, indeed the respondent skeleton didn't even address the question of sufficiency of inquiry because it was conceded that the second gunning criterion had not been fulfilled. And so that matter was not the subject of argument. Now, it's right to note that Mr. Justice Griffiths, in his judgment at paragraph 49, says, I don't think this would amount to a breach of the tame-side duty. That's obiter. That was not the pleaded case. And so there is a real disadvantage to the respondents in the way in which this matter now it's sought to be raised by the Secretary of State for the first time in this court. Had it been raised at the pre-action or summary ground stage, as one would have expected, the claimants could then have pleaded and argued an alternative position. Didn't do so because the issue simply didn't arise for consideration. But turning then to the fundamentals of the argument, the starting point. I'm sorry, my lord. Does my lord?
No, I'm sorry. I'm puzzled by that, Mr. Richards. I don't understand that case with prejudice.
Let me make it.
Mr. Justice Griffiths dealt with a number of points on as to whether there was a duty to consult.
Yes.
Up to about paragraph 49, he decides every point in favour of,
yes,
of the respondents, as it were. Then says, however, I turn to the question of voluntary consultation. On that issue, he found in your favour. Are you saying that if the defendants in their skeleton argument before Mr. Justice Griffiths had said, well, this was a voluntary consultation, therefore there was no duty, that you would have brought an entirely different case?
Sorry, the fault is entirely mine, my lord, for not making the position sufficiently clear. The argument that is now made for the first time is that the gunning requirements do not apply to a voluntary consultation, and that if a claimant therefore if that's correct, if a claimant wished to challenge the sufficiency of inquiries that were undertaken, they could only do so by reference to the tame-side duty of inquiry, the duty to take reasonable steps to gather information. That's the argument that's now being advanced. But before the judge at first instance, and well before the matter got before Mr. Justice Griffiths, it was accepted that if this was a consultation, then the gunning requirements applied, and it was accepted that the second gunning requirement had not been fulfilled. So there was it wouldn't have been on the horizon for the respondents to say, oh, well, we must anticipate that even though that's the argument, and we need to put the challenge in a different way because the Secretary of State is going to argue something differently. There was an alternative way of putting the case that would arise only if these arguments were correct. But the arguments never having been raised, it's not the way in which the claimants would need to put the case, because they were relying on gunning, which was said to be and accepted to be the applicable approach if it was a consultation.
So you're saying, had you been alerted to this point, you would have run a tame-side argument?
Or may have done, and I wasn't involved in the court below, and I can't put myself back in time, but that's the claimants have been deprived of the opportunity. Yes, the claimants.
Those sitting behind you.
They might have done. Yes,
they might have.
They might have done. Prejudice isn't required in terms of the decision of this court as to whether it allows these arguments to be advanced and the Secretary of State to run this point for the first time here. But that is a respect in which the claimants may have been prejudiced. Sometimes there is prejudice because different evidence would need to be put in. Well, we don't suggest that different evidence needs to be put in order to respond to the new argument.
This is a pure point of law.
This issue is a pure point of law, yes. The question is whether, had that pure point of law been flagged up at the first instance, other fallback arguments might have also needed to be deployed.
I'm just trying to think of what Tameside case could have been put forward but wasn't.
Well, the Tameside case, it would be to say, and the Tameside argument would run in this way. The Secretary of State says gunning isn't the applicable requirement. The Secretary of State says that the only way of challenging his decision-making process would be on the basis that there was a breach of the Tameside duty. And so that would be pleaded and argued. I drew attention to paragraph 49 of the judgment because the judge, as it were off his own motion, actually says, well, I don't think Tameside would work. But it was never argued in front of him.
Well, there is an irrationality ground or subground.
Yes.
In the statement of facts.
Yes. It wasn't proceeded with because it was common ground once the defendant's responses came in that the second gunning criterion had not been complied with. And so that was really having that concession was sufficient for the claimant's purposes.
In paragraph 61, page 139, seems to me to state in different legal language some of the criticisms which you've made today and which the respondents make in their witness statements about the inadequacies of the
yes. What you don't have. I'm sorry.
Yeah.
What I don't think you have in the bundle are the skeletons before the court below,
Yeah.
In which is, there's an argument about disabled persons' organisations, public sector equality duty, neither here nor there. Those were not successful. But in relation to the key position about the survey, says this: the defendant maintains the survey was not a consultation. So that's the issue that was clearly live between the parties. But accepts that if it was not done in compliance. Since this latter point is not in dispute, this skeleton doesn't address why the survey didn't comply with the second gunning requirement. So there was no need to develop the point or to characterise it through different legal prisms because the point was accepted. So it's a small point. I've taken up far too much time of the court on it. It's a small point, which illustrates the problems that may arise when points are taken for the very first time by the Secretary of State.
But hold on a minute. If you lost on your first argument, so say the judge hadn't accepted that this wasn't consultation, it's practically gunning requirements, you'd have been left without, your team would have been left without the possibility of running Tameside in the alternative.
Conceivably, but the argument that was run by the Secretary of State, if deployed at the proper time, would have thrown that into sharper focus.
Right. And
its relevance into sharper focus. So as I say, it's really illustrative of the problems that can arise when things points are taken at the appellate stage for the first time. Can I then turn to the authorities? And I'm going to deal here with the authorities on what happens when there's a voluntary consultation. I'll come on to the question of per curiam and then the Hetherington line of argument. So you have the Cochrane case at tab 5 of the bundle, page 137. You will see the constitution of the court. If James is able to describe a divisional court as a strong divisional court. I'm entitled to describe this as a strong court of appeal, particularly in public law terms, when one sees the presence of Lord Warden and Lord Justice Sedley. Consultation was a live issue in the case. Just to head off any per and curiam argument, although I think the focus of the argument has shifted away from per and curiam. Tameside was before the court. We see that in the list of authorities at the top of page 216. It was a case peopled with public law luminaries such as James Gowdy QC, Michael Fleming QC, Richard Gordon QC, and Philip Havers. And then in the judgment of the court, if we go to page 182 of the electronic bundle, so page 108 of the report, paragraph 108 of the report, it is common ground that whether or not consultation of interested parties in the public is a legal requirement, if it is embarked upon, it must be carried out properly. Then we have the gunning criteria set out, and then the court goes on to analyse whether, on the facts, the complaints of breach of the gunning criteria were made out, and concluded, in fact, that they were not. A description by a court such as this that it's common ground is not an assumption. It provides no indication of matters not being reflective of the views of the court. I wouldn't say it's common ground between counsel, because it's common ground. It was accepted by the court to be the position.
But the court didn't hear argument about it, so how can it be binding?
But I don't think one can tell from the judgment whether or not the court did or didn't hear argument about it.
Well, it's unlikely they would have done it if it's being said that it was common ground.
Well, something could be common ground because it's obviously accepted to be correct. It doesn't mean that the court's acceptance of that makes it not part of the ratio or not binding. I will come on to Hetherington in due course. But this is the Court of Appeal, in my respectful submission, essentially saying this is correct. This is the position.
It comes to this, it is very persuasive that, as distinguished a collection of people as Lord Wolfe, Lord Justice Mummery, Lord Justice Sedley, and all the experienced counsel who appeared in court, all thought that this was a correct statement of the law. But I was brought up in the view that a decision of the Court of Appeal is not binding unless it has decided something which was the subject of argument on each side, and they accepted one side, rejected the other, and it was essential to the decision. Otherwise, it's only persuasive.
Well, obviously, on any view, it's persuasive. It is. Can I come back to the question of its status when I come to the authorities that Sir James took?
Well, I think it's very important because if it doesn't look to me as though either of you has been able to produce a decision in which this court or the Supreme Court or the House of Lords has decided this point in a sense which is ratio. Because if it has, then that's the end of it. It doesn't matter what we think of Sir James's point. We're bound by the previous decision, and that's that. But that doesn't appear to me to be the position.
Yes. I would suggest that the Kadim case is somewhat narrower than that. We can go to it now if it persists. So it's the Supplemental Authorities Bundle 939. We see the general principle in paragraph 33. subsequent court not bound by a proposition of law assumed by an earlier court that was not the subject of argument for consideration by that court. But then if we go to paragraph 38, bottom of the page, it says this rule must only be applied in the most obvious of cases and limited with great care. The basis of it is that the proposition in question must have been assumed and not have been the subject of decision. That condition will almost always only be fulfilled when the point's not been expressly raised before the court and there has been no argument upon it. And then skipping over the references to the authorities, and there may of course be cases, perhaps many cases, where a point has not been the subject of argument, but scrutiny of the judgment indicates that the court's acceptance of the point went beyond mere assumption. Very little is likely to be required to draw that latter conclusion, because a later court will start from the position encouraged by the judicial committee that its predecessor did indeed address all the matters essential for its decision. That's the basis on which I say it's a slightly narrower than simply saying, well, we can infer that it wasn't argued because it was common ground. The condition here is said to be that there will be cases where the court's acceptance of the point go beyond mere assumption, very little required to draw that later conclusion. My submission, when we look at Cochrane and some of the later authorities, not all of them, some of them just reference Cochrane, but some of the later authorities, there is an acceptance that goes beyond mere assumption.
But the Kadim is referring to the more specialised situation where, although the rule is part of the ratio of the case, nevertheless, it can, in very limited circumstances, be disregarded. But unless the rule is part of the ratio, then it doesn't, you're not into Kadim territory.
Well, in my respectful submission, it is part of the ratio in this and other cases, of Cochrane and some of the other cases. It's the basis upon which the court proceeds. It wasn't a statutory consultation case.
But as a matter of fact, there was a consultation in Cochrane. Nobody was denying it.
Yes.
Because they were about to shut Marlon House, which is an NHS facility, and move the patients who'd previously been NHS patients into a local authority facility where they wouldn't be entitled to NHS care. So,
Yes, so this tells us nothing about...
No, so they recognise, those making the decision recognised that they needed to consult.
Well, there was a decision to consult.
Yeah, and they did carry out some consultation, as one sees from the paragraphs underneath paragraph 100.
They did indeed. Obviously, one wouldn't be getting into the gunning requirements if there hadn't been a consultation. The point is, the court is here saying those requirements apply whether you have a duty to consult or you have voluntarily consulted. That's a finding of the court. It may be right, using the phrase common ground, nobody argued against it. I accept that. Although I don't think we know the detail we don't have the detail of the arguments. They all thought it was correct. There has been, we've set out on our skeleton lots of authorities which have taken the same line. I'm not going to take you to the vast majority of them, but can I just show you I think a handful of the cases. So tab 15 is the case of Elisabeth and the National Institute for Health and Clinical Excellence, and the decision of this court, Tuckey, Jacob and Richards, LJJ. And the relevant passage, it starts on page 479 of the authorities bundle. And the relevant passage is on page 490. you will see there was a live issue in paragraph 24 as to whether this was a voluntary consultation that the court did not resolve because, and we see this the last few lines on page 490, in any event, whether or not consultation is a legal requirement, if it is embarked upon, it must be carried out properly. And obviously, it relies upon properly, but that is the court itself again making clear, again, a very distinguished court, its view of the position. And then, in terms of a more recent decision of this court, tab 28, the case of MP and the Secretary of State for Health and Social Care, for Justices Macur, Moylan and Newey, starts on page 838. And paragraph 29, where the court says, where a public body embarks on a consultation, then whether or not the law required there to be one, the consultation must be carried out properly. So again, that is a statement of the court, and then reference made to the gunning criteria as approved in the case of Cochrane.
Say something, Mr. Richards, I'm behind you. What?
I'm sorry,
The
page
last
849 of the authorities bundle, tab 28, the case of MP and the Secretary of State for Health and Social Care. So it's a more recent decision of this court.
Yes.
And it's again the court, in my submission, setting out its view of the position. And then we've listed in our skeleton argument a number of authorities where, again, judges of the administrative and divisional court have themselves articulated that same conclusion. Perhaps the only one I will take you to is the Medway Council case, that's tab 8. So I should say, it starts on page 269. It's a decision of Mr. Justice Maurice Kay, as he then was the lead judge in the administrative court, and it's the bottom of page 279, where he says, in my judgment, it is axiomatic that consultation, whether it is a matter of obligation or undertaking voluntarily, requires fairness. And then in the end, Mr. Corner did not dispute it. So not accept, dispute it, but more than just a recitation of earlier authority. It's another example, and there are plenty of others in the examples we've given, of the court itself saying that that is its view.
I'm so sorry, Mr. Richards, I'm several seats behind.
I'm so sorry.
No, it's my fault. Which tab, please?
So that's tab 8.
Tab 8, thank you.
Mr. Justice Maurice Kay, and it's the bottom of page 279 over to the top of page 200, paragraph 28 of the judgment.
Thank you very much.
So, as I said, I wasn't going to refer you to any further authorities. There is just one. I'm sorry. Wagstaff, tab 6 of the bundle, divisional court, Lord Justice Kennedy, Mr. Justice Jackson, starts on page 185. And it's page 207. Under the heading failure to consult. And there's discussion about there being no duty to consult. And then just below the letter G, we accept that, so this is the court accepting that where consultation is embarked upon, whether or not it is the legal requirement, it must be carried out properly. So if we just turning back to the supplemental bundle of authorities. Just for the court's benefit, but I don't think in light of the way in which the case has been argued, I need to take you to them. The original argument had been, or a part of an argument had been, that the decisions were the Cochrane line of authority was per incuriam. I think there was a suggestion in relation to the arguments not having been deployed before the courts. We put in two authorities, which are the case of Denus and Newham London Borough Council and A versus Kent County Council, at pages 941 and 987 respectively of the bundle. Because the case is no longer really put on the conventional per incuriam basis by Sir James, but is on the Hetherington basis, they may not assist further, but can I just give you the references in any event? In Denus, it's pages 962 to 3, paragraphs 71 to 75, and in the Kent County Council case, it's page 1006, paragraphs 38 to 41. And insofar as cross is concerned, if you could turn please to page 1012. And the passage which Sir James took you to, so it's the last passage of the excerpt on 1012 in the supplemental authorities. What's said there, or the reference there, is to where it can be inferred that the deciding court did not address its mind to a proposition of law. And in my submission, that's not something that can be said by reference to the authorities which we have looked at. So for those reasons, and before I deal then with the merit of the argument, we submit that on any view it's a highly persuasive line of authority. It's been the accepted position for over 2 decades. It's been endorsed by court after court, judge after judge, not been contested by central government, indeed been expressly accepted in some of the authorities as being correct by central government. We would go further and say it doesn't fall within the Hetherington and Kadim and Cross exceptions for the reasons I've already outlined. But in any event, it's obviously correct. As Mr. Justice Maurice Kay put it, it's axiomatic. If you have decided to embark upon a process of consultation, that is a process which must be undertaken fairly. And it matters not whether the route is statutory, legitimate expectation, conspicuous unfairness, or you've decided to do it. Once you've decided to do it, basic principles of public law, something you need to do rationally, obviously, but something you need to do fairly. And the gunning principles are not onerous, they're not complicated, they're very basic. And if we stand back and look at each of them in turn, the logic of the Secretary of State's position, the argument that these cannot possibly apply to a voluntary consultation. We take the first gunning principle, we must do this at a stage when the proposals are at or decision making is at a formative stage. The logic of the Secretary of State's argument is we can decide to embark upon this process where we seek input, whether they call it a consultation or not, but we don't have to do it at a point in time when we've still got an open mind. So we've already decided it can be a facade on that basis. The requirement that you do this at a point in time where you have an open mind applies logically just as much to a statutory consultation and to a voluntary consultation. It's a nonsense to suggest, if you've decided you're going to consult, that you don't have to do it at a point in time at which you still have an open mind. Likewise, it would be a nonsense to suggest that you don't have to consider conscientiously what has been returned to you as part of this process. So that's the fourth gunning criteria. The conscious consideration to the outcome of consultation. If you voluntarily decided you're going to do this as a public decision maker, nonsense to suggest it would be fair or lawful to do it, but say, well, actually, we're just going to completely ignore it. I know we said we were going to do it, but we're just going to completely ignore it. Likewise, the requirement that you give sufficient time. So, on this hypothesis, we've decided to consult, but we can do it in a way that doesn't actually give those who we're consulting the time to respond. Again, that is, in my respectful submission, absurd to suggest that that would be a fair or sensible decision-making process. And then we come to the criterion which is in play in the present case, that you give sufficient information to enable intelligent response. And if you have decided as a public body that you want to consult, you're likely to be doing so for one of the reasons identified by Lord Wilson in Moseley, because that's the purpose of consultation. You're going to be doing it because you want your decision to be better, you want people not to feel left out, you want the benefits of democratic public participation, whatever it might be, you've decided to do it, but you don't have to provide the basic information that enables intelligent responses. Because that's all that gunning is concerned with, those fairly basic requirements of fairness. And you don't need the origin of the duty to be fairness for fairness to apply to a decision-making process. So that link which Sir James made is incorrectly made. There may be many decision-making processes, nothing to do with consultation in a conventional sense, in which a public body says, well, I'm going to follow, I'm deciding, it's entirely up to me, and I'm deciding to follow this particular process as to how I will take this decision. They have to do so fairly. Fairness applies across the board of public decision-making. What it requires in given context will obviously vary. But here what we're talking about is so basic in terms of the gunning requirements that it's a nonsense to suggest that voluntarily deciding to undertake the process of consultation magically wipes away those specific requirements. And we've summarised that essentially in paragraphs 56 through to 60 of our skeleton argument. I don't propose to go back through those. My ladies, will you forgive me if I just turn my back to see whether there is anything further to it? No, thank you. Those are our submissions and the reason why we say the judgment should stand.
Thank you very much indeed. Ms. Roach?
Follow me.
Sir James?
Some short points, if I may, just by way of reply. Firstly, my learned friend went to Moseley, or back to Moseley, dealing with this distinction between procedural fairness and rationality. Can I just invite your attention back to Moseley, please? It's behind tab 20. And the passages that I want, which, sorry, I probably should have taken you through an opening, but I just wanted to flag for your note that when you're thinking about these issues, Lord Reed, as ever, had something crisp and useful to say, and page 597, is Lord Reed, and the two paragraphs that I wanted you to flag, one of them is already sidelined, which is 38, but just before you get there, can I invite you just to cast your eye down 35 on page 597.
Well, I was just checking, so that the last two members of the court agreed with both judgments.
They did.
So there are 3 votes for this judgment.
Yeah.
Is it what?
Yeah.
Okay, thank you.
Yes. Lord Wilson with Lord Kerr. So Lord Wilson and Lord Kerr produced the first judgment, then Lord Reed, and then the other two agreed with both. Yeah, so 3. So it's 35 and 38, if you would, just to bear those in mind. In answer to my Lord, that's one very short point on the authority. In answer to my Lord Justice Bean's question about whether, and if so, where and how did the learned judge grapple with the question of what a consultation for present purposes means, the answer, I think, is, as you've seen from the passages in the judgment that you've already been to, is that he doesn't really grapple with the ingredients or the definition of what a consultation is relevant for present purposes, recognising the point that my lady made, which is that consultation can be used in a variety of different ways by different people. But the judge doesn't say what it is that he's taking to be consultation. What he does instead is to identify the fact that it is correctly that it's a matter of substance and not form, but doesn't go much beyond that. However, it is perhaps worth bearing in mind that if you go back to the judgment at paragraphs 58 and 59, and particularly paragraph 59, and again, I don't want to be unfair to the judge, so this may not be, this isn't crystal clear on the face of the judgment. What appears to have happened, at least, is that he takes the passages from Lady Justice Simler in FDA and then identifies correctly its substance and not form, and then effectively takes her finding in paragraph 59, what took place was at best an exchange of information on some issues, therefore she rejected the case that it was consultation, and then, as it were, almost flips that backwards when he comes to the analysis in 60 and following. In other words, if it isn't just an exchange of information on some issues, he's treating that as being closer to consultation. I put it that way, I hope not unfairly, because although he doesn't actually say that in terms, when you look at the features that he then places reliance upon in 61 to 65, that is in effect what he's doing. So that's at least as close as one gets to answering the question, I think, that my Lord Justice Bean put. That's the second point. The third point is that there were some questions that were directed to my learned friend about whether or not, in essence, I think they came from my Lady Justice Laing, in essence, whether her case was that in order to avoid a breach of all of the principles of gunning, whether it would have been necessary for the strategy to have been attached, in effect, to the survey. And the answer that came back, perhaps very surprisingly, was in substance, yes. Or at least the things that fed from or that were in the strategy, there should have been further indications about. But the difficulty, of course, with that submission is that it places the government in an impossible situation, because the strategy and the various things that might or might not happen in the strategy hadn't yet been formulated at the time that the survey was promulgated. And once that is recognised, it becomes evidence that that answer effectively places both the substantive and the temporal cards before the horse. So we respectfully submit that cannot be right. So then, fourthly, there was some probing, I think, particularly by my Lord Justice Bean, about, well, what would it be? What examples have we got? What examples can be hypothesised to tease out when, on her case, something would or wouldn't be consultation? And the questions were asked in relation to some of the documentation that you were taken to in the precursor to the survey. Would it have been a consultation if they just put out that document or something like it? And my respectful answers to the case that was being made on the back of those documents by my learned friend was that the position she ended up in suffered from a number of difficulties. Firstly, she ended up in a place where the duty of or the consultation moniker would be attached in a very, very wide group of circumstances. Indeed, by reference to the horizon tour of the documents relied on by the judge, one can see that point in spades. It would be an obligation to comply with gunning at points and in relation to exercises that government traditionally undertakes very frequently. It would apply in an extraordinarily wide set of circumstances. That's the first objection. The second objection is that it would impose on that case, and probably because of that fact, what would be in effect an impossible obligation, because you'd have to comply with gunning on case one, on ground one. You'd have to comply with gunning as soon as the characterisation applied. And that is, to some extent, the central vice of what's happened here. You create, as it were, an impossible set of obligations for the government to comply with. The third difficulty that my learned friend faces, having given the answers that she did, including in particular, that the document referred to, I think it was at judgment paragraph 26, I think my Lord Justice Bean put that as an example, and the answer that came back was, yes, that was consultation, or that would have been consultation, because it was eliciting views and general information that might feed into or inform what ultimately came out in the strategy. So the answer, yes, was given to that. The difficulty that my learned friend has, of course, is that she is, and her client is, no longer challenging any point prior to the survey, of which that was one. So it's the incoherence that I mentioned earlier. And if you want a confirmation that that previously mounted challenge had been abandoned, probably the clearest reference is in footnote 5 in the core bundle at page 209. Which I think is, yes it is, it's the claimant's skeleton argument below. I think she suggests you didn't have those in your bundle, you do. This one's core bundle, tab 20, page 209. And you see what footnote 5 has to say for itself. My learned friend's core submission appeared to be that the judge was entitled to make a finding in effect of fact and to come to the conclusion he did on the material before him, and that he was entitled to reach the view in particular that he reaches in judgment at paragraph 66. And our short responsive answers to that submission are that he was not so entitled because, in very brief summary and without going back over the points I made in opening, he approached the question as to what was required in order for this to be characterised properly as consultation, either not at all or in the wrong way, or in the wrong way, for all of the reasons that I've given, including a need to have a look at paragraphs 58 and 59 as the lead into the paragraphs that then follow. You've got to have a yardstick. You've got to have a standard or a set of ingredients for what amounts to consultation. Otherwise, you've got nothing to judge the facts against. And if you go wrong at that stage, as we respectfully submit that he did, then that floors the entire analysis. But secondly, on this point, we do maintain the submission that what appears to have been that core error of principle in fact fed through to the analysis of the various features of the case that he undertook in paragraph 61 to 65 of the judgment, and that those were flawed for all of the reasons that I gave when analysing those particular paragraphs in my opening, which I don't repeat. My learned friend, on a number of different occasions and for a number of different purposes, castigated me, as it were, for over-egging the nature of the gunning requirements and asserting that they were onerous. I hope I will be forgiven for straying not really very far at all, if at all, from the language of Lord Justice Elias that you saw in the Association of Personal Injuries case. The language that he used, and it's evident that he used it in the sense of making the broader point that you should not create a difficult and onerous set of obligations, save in rare cases, as it were, because that would undermine good governance and all the other things that he was referring to in that case. The phraseology he used, both of these in paragraph 44 on page 540 of the authorities bundle behind tab 18, were the panoply of procedural requirements associated with consultation. These are all references in effect to gunning. And then, perhaps even more pejoratively, as he put it in 44, all the baggage inherent in the process. So that is where I took, and I'm perfectly content to rest on those descriptions. That same point, that same underlying point, and it's a direct, as it were, answer to the criticism of my submission that when characterising, you should characterise it as consultation only rarely. Can I just give you one other reference or remind you of one other reference on that point, but it also goes to Lord Justice Elias's point about not imposing that panoply of obligations or all of the baggage unnecessarily or save in rare cases. One other reference is back into Plantagenet, if I may, paragraphs 98.3 and 98.6. So 98 sub 3 and 98 sub 6, which are, again, in the authorities bundle, you have the references. I gave it in an opening. So that's all I wanted to say by way of reply in relation to ground 1. On ground 2, if I may, so far as the permission points, if I can put it that way, are concerned, you've seen the case law, and I'm not going to go back to that. In essence, the Johnson case behind tab 29, which you've looked at with both of us, the assistance of both of us, in effect identifies pure point of law, no findings of fact needed, an explanation as to why it wasn't run below, and lest anyone was under any illusion about that. The actual answer to that is because the point, perhaps unsurprisingly, occurred to some or all of us late. But one can see, if I may respectfully say so, how that occurs, because it is, as it were, something which is linked in to the first ground. I said in opening that there was an overlap between the 2 points, and it was thinking about the way in which ground 1 worked that eventually led us into ground 2. So it's no more straightforward or complicated than that. And then finally, no prejudice. My learned friend said that she suffered prejudice, or they might have suffered prejudice, because if only they'd known that ground 2 was going to be run, they could have pleaded and run alternative Thames-side arguments. And I wanted to make 2 points in response to that. The first of them is that if you just take up the judgment again, if you would, you will see that, and go to paragraph 48. You will see the context and setting for the dispositive finding in paragraph 49. Not persuaded, says the judge, that consultation was legally required in order to avoid conspicuous unfairness or irrationality. even if which the defendant does not accept irrationality can be separated from the conspicuous unfairness exception. So you see the potential elision between conspicuous unfairness and irrationality. But the judge is addressing both. Conspicuous unfairness, which is one of the triggers for the duty to consult, and also irrationality. But it wouldn't terribly matter if he just said conspicuous unfairness with irrationality being run to demonstrate conspicuous unfairness. But that's what, that's the nature of the issue that is then being dealt with and disposed of by reference to Thameside, having considered the issues in the light of the facts before him, in paragraph 49. See also, however, for the separate irrationality argument that was in fact being run, paragraph 6, Roman 3 of the judgment, at page 33 of the bundle, para 6, Roman 3. So you see the point being squarely raised as an irrationality point. And see also, for present purposes, if you still have the skeleton argument of the claimants below to hand, can I just invite you to go to page 216 in the core bundle, so 216 of the core bundle, and the paragraphs that I want, and the title above them that I want, are at the bottom of page 216, and can I just invite you to cast an eye across the title to issue C and into paragraphs 52, 53 and 54 so you can see what argument is in fact being run. And that is, I respectfully submit, destructive of the prejudice point that my learned friend seeks now to erect. So that's Johnson. In relation to the concession and whether or not there was a concession, my submission is that if there has been a concession, as is the position if you have a statement of common ground where one party could have argued that it hasn't, if there is a concession and there has been no argument about the point, then that brings you squarely within the line of case law that I took you to in opening. And my submission in response to my learned friend is that mere repetition and citation of the authority that was so based cannot improve the position. And it is clear, whatever language was used by the courts that followed, it is clear that in none of them was argument raised about the issues that now confront you. There was simply, in all of those cases, this isn't a semantic debate, in none of those cases was there any form of argument about the point. There was simply mere repetition or assumption that that bit of Cochran, that common ground bit of Cochran, was correct. And my respectful submission is that that brings you within it. And if one wanted to stand back and approach the matter as a point of pure principle, ultimately the principle of stare decisis exists for good judicial management and orderly judicial management of issues. And the courts, by and large, stand for resolution of issues when and if they are squarely raised. That is why we respectfully agree with my Lord Justice Bean's instinctive reaction and description of the principle, which is that you haven't had argument on something, the point hasn't truly been disposed of. So we submit that for all of those reasons, this is within the territory of permissible and non-binding finding below. So I'm not left to just run this in the Supreme Court. It is open to you, and we respectfully submit that you should rule on the ground to issues. And so far as ground 2 is concerned, my learned friend on the substance of it, my learned friend correctly identified the nature of that ground. Our submission is that if the consultation is voluntary, you've lost the engine of the rocket, and the test should always be rationality. That isn't a deficit in public law terms, because, as you know, rationality is a concept which is, or has at least some flexibility within it, and it is not met as a submission by saying we'll take these absurd examples. If someone does it when they've got a totally closed mind, what's wrong with that? The answer to that is that if that was truly the case, very difficult to see why in any circumstance that would be so, but if that were truly the case, then that might be thought that that sort of example would found a classic case of irrationality anyway. So we do not accept that the substitute which ground 2 leads to, which is irrationality, is in any way deficient in terms of proper public law control over voluntary consultations. So for all of those reasons, we do invite you both to consider and to decide ground 2 in our favour. And ladies, my lord, those are my submissions.
I think Miss Richards looked rather askance at one of your assertions, James, that she'd said that you'd got to attach a draft strategy. In fact, my note said that she said you do not need to attach a draft strategy.
Oh, well, I may have totally misheard her. She's standing up to correct me on that. She has my unreserved apology. But if it's the if the idea is that you need to take back a proposal which hasn't yet been formulated, that has obvious absurdity. That's not the submission.
I think that was Miss Richards' point.
And I don't want to, I don't want to misstate her position, shoot at straw men.
Thank you. Thank you very much indeed. We will reserve our decisions. The drafts will be sent out in the usual course. Editing invited. No further arguments, save and except for these 2 authorities, Miss Richards. If it's going to lead nowhere, I wonder if you could still make a nil return so that we know not to expect anything.
My lady, I'll look at them this evening and I will confirm with the court and with Sir James and his team whether we think they're relevant or not. Either way, so that you know the position. And if our submission is, once I've had a chance properly to read them, that they are relevant in response to some of the questions that were asked, we'll provide copies. But if they aren't...
And written submissions.
And written submissions.
Yes.
Yes, absolutely.
And, obviously a
I'll do that overnight, my lady.
Thank you very much indeed. Thank you. Nothing at all. Yes, you will be aware of recent authority regarding breach of embargo, but I make that point as a matter of course rather than any suspicion that anybody's going to do anything. Thank you all very much indeed.
Welcome.